So all of you must possess the Bear Act. Bear Act. And those of you want to do some serious research, I suggested to you Batuk Lal and Munir's book, and also we have even our Chief Justice of the Bombay High Court who went to Supreme Court, Justice Thakkar's book also is there. Good research book. But personally speaking, I prefer the Bear Act, and judgments are available on the net. There less confusion is created. With the textbooks, conflicting opinion, they are good. Some of them are good. Giving I find Batuklal and Munir and is good, and also our Chief Justice Thakkar's book is very good. There is also the well-known authors Sarkar Wara bhi hain. Those who want to do serious and more research, then many authors. Those of you who want to avail the indulgence and benevolence of our friend Mr. Shetty, go to Sundardas Ganchan. He is also on our group. I will request him to give substantial discount to all the students. He is very kind and great gentleman. He will give you all the books. And he is a very good friend of mine. And I can request him. All of you near Metro Cinema के पास जाइए. He gives a student special discount. एक copy ले लीजिए आप. And please, without Bear Act, you don't appear. Copy of a Bear Act is a must. तो कल का लेक्चर समझ में आया आपको? Isn't it all of you? नहीं समझ में आया नहीं yesterday's lecture?
Yes, sir. It was clear, sir.
Yes, very clear. So I was a little on the point. Then before you drew my attention that the Raghav was reminding you of the lecture. In the court of law, essentially the role of the Evidence Act, once again to recapitulate, I would say that it's a procedural law and a connecting law, connecting law, where Sir John Stephen is the main author who has adopted this Indian Evidence Act from the well-known Taylor's work of the English law. आप देखेंगे essentially the object and purpose behind the Evidence Act, all of you should know it that here, the two parties go to the court of law, the plaintiff and defendant, in the court of under the civil and in the civil litigation. In the criminal litigation, the prosecution through the state and the accused persons go to prove their cases here. Now, I will give you both the illustration. What is the role of the Evidence Act? At what stage is come to play? Now, in civil cases, after the pleadings are completed, namely plain written statement khatam hone ke baad, of course, the introduction of the documents, documentary evidence, because under the scheme of the Evidence Act, they have explained documents. Document is a very wide word, which includes letters, figures, marks, identification mark, caricature, maps, the inscription. If you see the definition, is very wide. These are all documents. Under the CPC, all of you know that the documents are first time introduced in the plane under the provisions of Order 7, Rule 14. All of you have learned it here. In the list of documents are given. Order 7, Rule 17, Rule 14 tells you if the documents which are not introduced or disclosed in the plane by the plaintiff, he will not be permitted to introduce them or rely upon at the stage of the evidence. At the stage of the evidence, please note that it is mandatory. Subsequent, it is not mandatory that you must disclose all the plain documents. Some may be in your possession, some may not be in your possession. But you are expected to tell the court by virtue of an affidavit who has in their possession the remaining document. Then with the leave of the court, Order 7, Rule 14 में subclause 2 कहता है कि with the leave of the court, yes, you can put the document at this stage of the trial when the pleadings are completed and when the court has framed the issues करने के बाद. That is one stage the documents are introduced, but the documents which are produced before the court of law, which are produced before law, not actually they are not automatically admitted unless they are admitted document under section 58 of the Evidence Act. 58 tells you admitted documents need not be proved. There are certain documents which the court will take judicial notice of. Um, Part 2 of the Evidence Act tells you the court may take judicial notice of certain document, that is the laws which are prevailing in the territory of India, the laws made by the parliament, the laws made by the legislature, the public acts which are passed by the UK at the time. The UK was controlling our country under the Government of India Act 1919 and 1935. वो यूके के बारे में काफी डिस्क्रिप्शन है एविडेंस एक्ट में, which you may not take serious cognizance of. Now it is replaced by the parliament and our own legislature. So the court which will take cognizance of, take a judicial notice of documents are described in section 56 and 57. Those documents you need not strictly prove. For example, a judgment reported in the Supreme Court of India, Supreme Court manual, EIR manual, the court will take a judicial notice. This is correctly reported, isn't it? So the 58 के अंदर भी the documents which are admitted, like lawyers' correspondence, map prepared by the parties, admitted correspondence normally are not proved by the court of law. But what is the purpose of introducing the documents during the course of a trial? That one particular section tells you in the Indian Evidence Act, section 3, that is called proved, disproved, and not proved. Proved mean now under the provisions of Order 18 CPC padhe hum, who should begin the case? Normally the plaintiff who has filed the case begin the case, but sometimes the onus will shift upon the defendant. If the defendant takes up the plea that the court has no jurisdiction, or the defendant will take up the plea that the suit is barred by limitation, or that the suit is barred by under the provisions of Order 23, namely previously instituted suit was withdrawn without liberty of the court. When you don't take the leave of the court, second suit is barred. Now, secondly, the suit was filed under Order 2, Rule 2 without the leave of the court. So you are not relinquished the cause of action. So in that event, or you may take up the plea that the suit is hit by the doctrine of res judicata under 11. So in such a situation, the onus probandi, the onus will shift upon the defendant to lead evidence. So there is no strict rule as such as to who should lead the evidence first here. Now that circumstances, who should lead evidence, who should not lead evidence, that is dealt under Part 3 of the Evidence Act, starting from section 101, dealing with burden of proof. Burden of proof, it's a very interesting chapter. We will deal with burden of proof. Who should, plaintiff ko karna hai, defendant ko karna hai. So normally the plaintiff files a suit for declaration that the agreement is sham, colorable, and bogus. Then the plaintiff has to step into the box. Agar defendant bolega, a similar suit was filed way back in the year 1975 by the father of the plaintiff, where decree was passed or the suit was dismissed, and the present suit is res judicata. Then the burden will shift upon the defendant, isn't it? That is a section 102 lag jayega uske andar, Indian Penal Code mein. So he will take up the plea. That is in the civil case, the defendant has to prove. If the defendant takes up the plea, the court has no jurisdiction. Normally, the issue of jurisdiction, nowadays the court is trying simultaneously along with the other issues under Order 14. Pehle CPC ke andar there was Order 9A, all of you know that now, which has now been deleted. Order on account of Order 9A, Section 9A, the proceedings were protracted ho rahe the, lamba ho rahe, and there was appeal provided, SLPs, there was a writ petition, as a result whereof minimum 10 to 15 years were lost in deciding issue of jurisdiction. As a result whereof, the parliament and legislature thought it fit that they should be deleted, because that particular issue is covered under Order 14, Rule 2. If the court suo moto decides, it's of the intention of the court that a separate issue should be tried on the point of jurisdiction or any technical law, The court has the liberty, but the parties cannot insist it must go on. It is the discretion left to the court. In that event, if the court chooses to say that here, I will first decide the issue of jurisdiction, then the defendant would be required to step into the box. And the onus will be shifted. That provision will be section 102 of the Indian Evidence Act, where the defendant will file his examination chief. Now he will file his list of documents, how they are produced. Then that provision will apply. So the law says that here, while considering whether the plaintiff, whether the defendant or the plaintiff, whoever is first being examined, they file a document called examination chief under Order 18 in civil cases, Rule 4, by way of affidavit. So while considering whether the court will decide whether the contention of the plaintiff that the agreement is bogus, has he proved it, or whether the contention of the defendant that the suit is barred by res judicata, or the suit is without jurisdiction of the court, or that the suit is barred by any other law for the provided, then the court will consider not only the pleadings of the parties, court will not only consider the documentary or oral evidence of the parties, court will say the matters before it. हाँ, आप देखेंगे सेक्शन 3 के अंदर the explanation proved क्या कहता है? It is said to be proved. Proved, a fact is said to be proved when, after considering matters before it, underline the word matters before it, the court either believes it to exist or consider the existence to be so probable. Probable means the court can draw inferences, the preponderance of possibilities. If there may not be a direct evidence, there may not be an indirect evidence, there may not be documentary evidence, there may not be direct witnesses, the court may consider probable, court may draw inferences which are provided under 114 of the Evidence Act. That is, the court may presume, the court shall presume, 179 से लेके 80 तक हुए. So the court will consider all matters before it, considering the non-existent ought to have circumstances of a particular action, supposing it to exist. So the court is considering all matters. For example, in a civil matter, it is not only in the plaint or documents produced here. Our defendant has introduced the document in the written statement under Order 8, Rule 1A, CPC, and subsequently filed the list of documents under the provisions of Order 13 of the Code of Civil Procedure. The list is before the court. See, the court will consider. Sometime the court will say that the matter, suppose you may take up the plea, the defendant says that here, I have effected the writ of summons upon the defendant in the suit premises. Suppose when an ex parte decree is passed by the court under the provisions of Order 9, so the defendant takes up the application under Order 9, Rule 13 for setting aside the decree. So defendant will come out with a plea, the decree has been passed fraudulently. Plaintiff ने हमको service ही नहीं किया है. I was not there at the premises at the relevant time. Plaintiff will say that the bailiff had gone there. I have a bailiff report, number 1. So that is a matter before the court. Please note that when the expression proved के अंदर लिखा गया, after considering the matter, the court will consider the bailiff report for the purpose of determining whether the writ of summons were correctly served. Number 1, that is one aspect towards it. Merely considering the bailiff report is not enough. Where court may examine at the request of the plaintiff or defendant, put the plaintiff bailiff in the box. He will be asked questions whether you are actually accompanied the plaintiff or his representative for effecting service. When was it? Date particular? ये सब पूछा जाएगा. Well, that is also a matter before it. Then the plaintiff may also take up the plea that apart from the bailiff report, my lord, I also resorted to the provisions of Order 5, Rule 20 CPC, namely substituted service. That is pasting कराया गया court premises में, number 1, through the bailiff of the court. And also the advocate's clerk was present. I am filing his affidavit. Then I send it by registered AD post, but you are also exhibiting a registered AD post. Then a CPC, then courier से भेजा गया. So that is all matters before the court. It's a matter. Then he will say that the court was also pleased to appoint a court commissioner at the relevant time. The report of the court commissioner is there. So it's a court of the commissioner is also a matter before the court. It can be read as evidence before the court of law. So it is not just the oral evidence जो आपका court में जाके बोलते हैं आप section 60 a direct witness is a only evidence. It is not just the documentary evidence, agreement of sale or assignment deed is not the mere agreement. The court will consider these are the matters. Underline the word. Yet your word matter, considering the matter before it, ये तीनों जगह use किया. Namely, proved में भी किया गया है, disproved. Mean the plaintiff will file the affidavit. Mean one of the parties, plaintiff or defendant, will file the examination chief to prove his case. That is normally the proof is invoked here, proved here. So for proving his case, he will file the examination chief and the list of documents. Then I will tell you how the list of documents are admitted before the court of law. That will be, he will be interested. For examination chief may, he must confine his evidence only to the facts in issue. The court which has framed, number one, whether the plaintiff prove that the prove that he has right title interest in respect of the premises. Number two, whether the plaintiff prove that defendant is a rank trespasser, does not have any right title interest. Number three, whether the defendant prove that the court has no jurisdiction, whether the defendant prove that the suit is barred by the doctrine of res judicata. ये चारों issue है. Then he will take up the plea. The suit is barred by limitation. That the suit is also hit by the doctrine of waiver. ये सब issues frame होते हैं. ये frame होने के बाद, then the court may toss it up whether I will try the and all issues together. अगर all issues साथ में जाएंगे तो plaintiff naturally will go in the box. But if the court decides to say that I am going to resort to the provisions of Order 14 Rule 2 of the CPC College, Order 14 CPC College, Order 14 Rule 2, when the court can decide issue of jurisdiction and legal question as a preliminary issue that is discussed under Order 14 Rule 2 में, of the college CPC होगा आपके पास दो. If I am not mistaken, all of you must be having it. I will draw your attention. Order 14 Rule 2 के अंदर देखिए, court to pronounce judgment on all issues, notwithstanding anything, notwithstanding that the case may be disposed of on a preliminary issue, underline this word, the court shall subject to provisions of 2 pronounce judgment on all issues. So the first mandate is that the court must take up all the issues together. So in which even under Order 14 Rule 2, the plaintiff will normally go into the box following the mandate under Order 14. Now, number 2 पे आ जाइए. Where issues both of law of fact arise in the same suit, and the court is of the opinion that the case or part thereof may be disposed of on an issue of law only, underline the word, on the law only, it may try the issue first if the issue relate to number one, jurisdiction of the court, underline this word, issue of law के ऊपर. Number two, bar to the suit created by any law for the time being in force. So jurisdiction of the court dealt under section 15, 16, 17, 18, 19, 20 of the Code of Civil Procedure. So you cannot file a suit for recovery of property if situated in Mumbai. You cannot file it in Pune court just because defendant is residing there. If a suit for recovery of a landlord suit in a city situated in Delhi court, you cannot go to Bangalore court to file a suit where the property is situated. But in the case of a defamation which took place in Bombay, plaintiff defendant may be in Calcutta, you may choose any of the court pursuant to section 1920 of the Civil Procedure Code. In a suit for administration where the property is situated in Bombay, Calcutta, Madras and Bombay, you can take the leave of the court under clause 12 of the latest patent or under section 20 leave leke, you can file any of the suit, well prior leave must be taken. So यहाँ पे issue of law has arisen on the jurisdiction. The defendant has taken up the plea in the written statement that this honorable court has no jurisdiction to entertain the present suit because the subject matter of the suit is not situated within the territorial jurisdiction of this court. In this event, the court can try this issue on law. Point number B, a bar to the suit created by any law for the time being. So what is the bar created? Under order 2 rule, under order 2 में पढ़े हैं आप, plaintiff to sue the entire all cause of action, and you cannot relinquish it. If you want to relinquish it, take the leave of the court. बगैर relinquishment के full fight कर दिया आपने, your second suit is barred. Similarly, under the provisions of order 23 of the Code of Civil Procedure, every plaintiff has the right to withdraw the suit. आपने two brothers have fighting together, you filed a suit, well, settlement talks are going on, intervention, I want to withdraw the suit. आपने suit withdraw कर लिया without the leave to refile it. Mind you that whenever your client tells you settlement talks going on, we are settling the matter, not filing consent right now, बाद में करेंगे, family में pressure आ रहा है, don't withdraw the suit without taking leave of the court to refile the suit on the same cause of action. अगर आप leave नहीं लेंगे ना, please open the consequences. I will tell you. Order 23 के अंदर your second suit is barred. देख लीजिए आप. So that is one circumstance. Order 23 खोल लीजिए, मालूम पड़ जाएगा आपको. Order 23 के अंदर rule 4 चेक करें आप. Rule 1 में
3A, bar to suit.
Yeah. Where the plaintiff abandons any suit or part of the claim or withdraws from the court without the permission, refer to rule above, he shall be liable to the cost court may award so and so from instituting the suit in the matter so and so. Nothing shall deem to authorize the court to permit any of the parties to abandon the suit here. So second suit is barred here. You cannot, isn't it? The withdrawal cannot be done without the leave of the court. So यहाँ पे bar is created. Under order 2 भी खोल लीजिए आप, order 2 rule 1, order 2 की, order 2 rule 2 CPC भी खोल लीजिए, bar यहाँ पे create किया गया है. देखिए, under order 2, frame of the suit to include the whole claim. Order 2 rule 2. Then order 2, relinquishment of the claim. Where the plaintiff omits to sue, intentionally relinquish a claim, he shall not be otherwise in respect of omitted to relinquish. Then where he cannot file the suit, yes, see, order 3 के अंदर, a person entitled to more than one relief in respect so may sue for all, and so if he omits, except with the leave of the court, to sue for the relief, he shall not be afterwards sue for any relief afterwards. So यहाँ पे बार लग गया इसको. Similarly, under section 80 of the Code of Civil Procedure, if you are filing a suit against the government, you are required to give a notice, 2 months notice. Agar if you don't give a notice and file a suit, and if you don't take the leave of the court under subclause 2, urgency ground, your suit is barred. So that particular issue, the court will try as a preliminary issue on the point of law, in which even the defendant will step into the box first, because the onus is shifting upon him under the provisions of section 102 खोल लीजिए यहाँ पे of the Evidence Act. The burden of proof in a suit or a proceeding lies on a person who would fail on evidence all to give either side. Then burden of a proof as to particular fact, 103 के अंदर, the burden of proof as to any particular fact and a person who wishes the court to believe the existence unless provided by law so and so shall lie on the particular person. So the defendant wants to say that the court has no jurisdiction under 103, burden will lie upon him in the matter. So here, taking into consideration the provisions of order 14 rule 2, the burden will shift. The burden will shift the court. Here the court has a right to frame the issue of law and which the defendant will be required to go into the box first. Okay, that is the issues are of the fact and issues of the law. I am talking only at the moment here, issue of law. So issue of law के अंदर, so the court will consider the various material proved and disproved, उसके अंदर all matters before the court. Now, when both the plaintiff and defendant step into the box, they introduce in the if it's a plaintiff under order 7 rule 10 rule under order 7 rule 14, documents are produced by him. It is mandatory. All documents except a document which is meant for cross examination of the other side, he need not disclose. That the reason why he is permitted to withhold a particular document meant for the cross examination of the other side, that answer you will get from section 100 and section 145 of the Evidence Act, which I will take you to later on. When the contradicting the 145 के अंदर मिलेगा आपको answer. Mean the previous statement of a person can be shown to him to contradict him. Like a statement recorded by a police officer under 161, you can use the statement in the cross examination to place it on record to show that here these are the statements signed by you, by the police. आपकी जबानी पुलिस के पास एक अलग है, आज एक अलग है, which is correct. A cross-examining counsel normally, when cross-examining witness, will not first point out to him what is said before the police. पहले पूछेंगे उसको, what are you doing in life? Where are you working in life? What is your livelihood? Timings of your office, where are you working? आपके ऑफिस के टाइमिंग क्या है? क्या खाते हैं, क्या पीते हैं? Isn't it? What is your age? Where were you born? Your qualification? The poor fellow wouldn't realize that he has said differently to the police under police instruction. समझे ना आप? So in the cross examination, then you will ask the gentleman, look here, I am drawing your attention to your previous statements. So similarly, for the purpose of res judicata, for proving it here, you are not only required to draw the attention of the plaintiff to the previous judgment which is signed, to the previous plaint which his father had filed. You cannot just take the plea of res judicata in the air. आपके पास, you must have in stock the previous plaint where the suit was originally disposed of in favor of the plaintiff or defendant, where a final decree is passed. वो judgment के अलावा, plaint के अलावा दिखाने का why the relief sought in the present suit or similar to the one which was sought in the earlier suit, वो भी दिखाना पड़ेगा आपको. Otherwise, you cannot straight away take up the plea of res judicata and win in the court of law. To invoke it here, you have to show that here the subject matter of the property is same. In respect of the subject matter of the suit, the plaintiff's father had filed a suit against the defendant's father in the year 1940 or 50, when he was not born or maybe a smaller person. I have a certified copy of the plain written statement of the issues. Issues must have been framed. A res judicata cannot take place on interlocutory application. It must be a decree. So the court will consider all these matters before it for proving the document. Now, when a list of documents are tendered by the plaintiff and defendant, because normally at the time when issues are framed, court gives a direction, both the plaintiff and defendant are directed to present their affidavits and list of documents. Then the matter is kept for the first, whoever files first. For example, a plaintiff will file his examination chief under 137, or list of document we file kar diya. List of documents are filed in various section. Number one, order 7, rule 14 of the Code of Civil Procedure, isn't it? Then order 13 of the Code of Civil Procedure along with the affidavit, a list of documents are given. And the defendant will file the list of documents under the provisions of order 8, rule 1A CPC, read with the provisions of order 13. Order 13 के अंदर लिखा गया what documents, relevant document. Then the next stage, when these documents are presented before the court, suppose for example the plaintiff will first the court will take up his examination chief. Examination chief के साथ में उसमें document भी रहेंगे, और document के साथ में how these documents are they were introduced, now how they come on record. Coming on record के लिए straight away the documents are mentioned. Of course, the examination chief which you file is coming under 137. See, the order is passed by the court with regard to, the court will say the plaintiff has filed the evidence and the list of document. the defendant is hereby called upon to give his say. That is called admission and denial of the document. Please note that this admission and denial of the documents will take place both under the provisions of CPC as well as your Indian Evidence Act. I will point out first the provisions of CPC. आप जरा खोलेंगे. Yeah, admission, denial, impounding of the document, and rejection of a document will take place under order 13. Okay, the documents which you are tendering, उससे पहले के अंदर आप उससे पहले at the time when the court has framed the issues, you have taken discovery, inspection and interrogatory submit किए under order 11 के हिसाब से. under order 11 rule 10 के अंदर वो inspection हो गया आपका. that you are bound to give both the parties here. Then the next stage before the court will consider whether the documents produced by the plaintiff are original document. The first mandatory requirement is that here the first preference is given to original document. That is the original document, the primary evidence, which is also known as the best evidence rule under the Evidence Act. So section 62 and 64 are the Evidence Act are to be first taken into consideration. 62 speaks of a primary evidence and 64 says the primary evidence is introduced by submission of the original document. Just open कर लीजिए आप section 62 open कर लीजिए. Primary evidence means the document itself produced for the inspection of the court. So this is the original document, a registered document. Even under the Indian Registration Act, आप देखें, if you have a copy of the, you have to keep also the copy of the Registration Act with you. Registration Act में, I will point out to you one relevant section, how the court takes into consideration the registered document on the face value. Certificate of registration is conclusive under the act here. Yes, और relevant section में बताता हूँ आपको मैं. Yeah. Yes. Yeah. Registration Act के अंदर आप चेक करेंगे particulars to be endorsed on the document admitted to registration, section 58. 68. Then section 60 tells you certificate of registration आपको देगा वो. After such provisions of section 35, 34, 35, 39 apply to document prescribed registration have been complied. Registration officer endorses the certificate content registered together with the number of such registration sign, seal and dated registration for the purpose of proving that the document has been duly registered in the manner provided. So this is the document which has been registered comes into play before the court of law. So that document is a section 60 in the Evidence Act. It's a registered document, original document. Now this original document is introduced in the Evidence Act under section 64. See that here? Proof of document by primary evidence. Document must be proved by primary evidence except in cases hereinafter mentioned. So the first requirement is that here, you will have to step into the box. The moment you submit the document here, the court of law, the trial court before whom the document is filed, will check your list, will pass an order on admission and denial. The defendant has to give his finding. The defendant normally would be interested in denying your document. वो document deny करने जाएगा आपको, उसका relevant section check करो आप, section 135 and 36 check करो आप. This is important. See, yeah. Order section 135 says order of production of examination of witnesses. The order in which the witnesses are produced and examined shall be regulated by the law and practice for the time being forced in CPC and CRPC respectively, and in the absence of law by the discretion of the court. So CPC will tell you how the witnesses are to be examined. Order 16 दिया गया है. CRPC के अंदर section 273 onwards. Please remember that. The inquiry trial के अंदर दिया गया उसके अंदर. Now, the moment the documents are tendered, for example, I'm giving you section 62 के अंदर, the judge is required to decide the admissibility of a document. So admissibility is one thing, relevancy is one thing, thirdly, proof is another thing. These three things are different under the Evidence Act. So admissibility, whether a document which is produced is admissible in the eyes of law, whether it is falling in any of the sections of the Evidence Act. Then number two, so for example, it is admissible. Admissibility and whether it is a relevant document. Relevancy of a particular document connecting with the varied evidence is given section 6 से लेकर section 57 of the Evidence Act. It has to connect it there. I will connect you each of the document when we are dealing with it here. Then the proof of the document, merely because admissible, merely because relevant, it is not enough. How do you prove the document? Mere exhibition of a document is not a proof. The contents are not proved. The content of proved, disproved or not proved, the court will decide it after examination of the witness and the counsel's help. Proved, disproved and not proved definition, please by heart kar lijiye aap. And I told you the court will considering the matters before it. Now 136 ke andar, the court will say the plaintiff has filed the document. The defendant has given his say. I admit the, for example, I admit the first document, namely agreement of sale, a registered document. Number B is an unregistered document. I am not admitting it. Number C, a Xerox copy of the registration receipt. I am not admitting it. Number D, a postal acknowledgement letter which has been sent. I am also refusing it. I did not receive it. So the court will ask the plaintiff. See here, section 136 is important. When either party proposes to give evidence of any fact, the court may ask the party proposing to give evidence in what manner the alleged fact, if proved, would be relevant. So, number one, you will have to prove before the court of law, you are proving your document by primary evidence. That is dealt under section 62 and 64. अगर वो document आपके पास नहीं है, then second option which is normally available to you, I am proving the document by secondary evidence. Now, what is a secondary evidence? And you, as a young lawyer, you will be required to bear in mind the provisions of section 63 and 65 of the Evidence Act. Now, 63 tells you the illustration. Abhi 62 हमने देख लिया अभी, primary evidence, which is the original document. Original document नहीं है आपके पास for A reason, B reason. So you may take up the plea. I want to prove this fact by secondary evidence. Now, what is the secondary evidence? You should know. Secondary evidence, देखिए section 63 खोल लीजिए आप. I will just explain to you. Secondary evidence mean and include certified copies given under the provisions in after content. So maybe your original is lost. Then you have applied for a certified copy from the department. You have a copy of it. That is acceptable. Then number two, copy is made from the original by mechanical process. So certain papers you have taken yourself Xerox copies. The original is misplaced. Or original may is faded. And then the copies compared the counterparts of the document as against. Then finally, oral accounts of the content of document given by some person who himself has seen it. Oral account also mean a oral evidence which is falling under section 60 of the Evidence Act. Section 60 speaks of oral evidence. Kindly see that here. Oral evidence means somebody who has seen directly, somebody who has preserved, somebody seen it here. A witness will say, yes, this particular will was signed by the testator in my presence. I was a typist who typed and gave it. आप देखिए यहाँ पे, the typist is saying, or maybe an advocate's clerk is saying, yes, the grandfather of the plaintiff, I know him. He is the client of Mr. X with whom, under whose employment I am in. I have seen myself, he is signing the will or a document which was prepared by my boss, my advocate. And he had brought. So it's a oral account. It is also becomes a secondary evidence. Please note that it is very wide here. 63 का सब clause 5 के अंदर. Number 1, under what cases you can lead this evidence is given under section 65. See that here? Secondary evidence may be given of the existence, condition, content of a document in the following cases. Number 1, कहता है कि when the original document is appeared to have been possession of the power of a person against whom document is sought to be proved. तो डिफेंडेंट के कब्जे में आपकी ओरिजिनल डॉक्यूमेंट है. You may take up the plea that year. The defendant came to my house. He put a revolver over my head and told me to sign the document. Sign लेके चले गया पूरा document. And he has submitted in the registration office. Registration is not giving me. I have challenged the document. It's a sham document, colorable document. So what will you do? You make in a court to the court of law. The original is not in my possession. I obtain only a copy which the defendant has given to the electricity department for obtaining electricity, falsely showing, representing that he is the owner of the property. So the electricity department, Reliance company or a BST gave me a copy that this gentleman wants to have electric connection to your premises, to your property. What do you want to say? So you raise objection. You raise objection for the first time. The agreement of sale, so-called, he has produced is bogus. I never signed this document with him. I never received any consideration. So you challenge the document under the Specific Relief Act, go for a declaration that the agreement is sham, colorable, bogus, document be set aside. Isn't it? You seek a declaration. In the declaration, when you sought, and you mention in the plain, the original document is not in my possession. I only have a copy which I received from the Reliance company, or which is furnished to me by the registrar. So that this honorable court be pleased to call upon the defendant. You give a notice to him. Look here, I have filed a suit for a declaration that the agreement of sale is bogus. I am leading evidence. I have filed my examination chief with a copy which I have. Now, since you are in possession of the original, I hereby call upon you to produce the document. Uske liye, you will have to give a notice under section 66 of the Evidence Act. Please note that. 66 full लीजिए आप जरा. Rules as to notice to produce. Secondary evidence of the content of a document referred to in 65 clause A shall not be given unless the party proposing to give secondary evidence has previously given to the party in whose possession the power the document or his document pleader such notice produces is prescribed by law. Is no notice prescribed in law from so and so such notice. So this is a mandatory requirement. Kindly note that. As a young lawyer, as a trial lawyer, a client tells you the original document मेरे कब्जे में है. So you don't become oblivious. So ये document आप disclose कर रहे हैं court को for the first time, a copy under the provisions of order 13. You are filing a affidavit of document under order 12. कहाँ पे आप आ जाइए. ऑर्डर affidavit of document कहाँ पे आएगा आपके? Discovery inspection order 11 में आएंगे ना, isn't it? Order 11 में प्रीमेच्योर डिस्कवरी एफिडेविट डॉक्यूमेंट ऑर्डर 11 रूल 13 खोलिए आप सीपीसी के अंदर। एप्लीकेशन फॉर डिस्कवरी ऑर्डर 13 में एफिडेविट डॉक्यूमेंट और 11-13 के अंदर में भी सी आई एम कनेक्टिंग इट टू यू टू द एविडेंस एक्ट डायरेक्टली, सो योर डॉक्यूमेंट्स आर फाइल हियर। या नाउ आप ये भी खोल लीजिए आपका सीपीसी के अंदर exactly the relevant affidavit. I'll show it to you. Order अपेंडिक्स बी खोल लीजिए आप। अपेंडिक्स बी के अंदर सॉरी अपेंडिक्स ए में रहेगा यार। Can you show it to me affidavit document anybody in the appendix in the कोई बता पाएगा मेरे को? It is there appendix B में रहेगा यार। When teaching CPC order 5 rule 20 summons for judgment, order 1 rule 10, order 5 rule 20, I am showing it to you right now the correct affidavit in that regard which is produced in the evidence I have in my possession which I object to produce, वो सब लिखा होगा उसके अंदर। ऑर्डर 11 इंट्रोगेटरीज खोलिए आप, अपेंडिक्स सी चेक करें आप। या
सर इट्स अपेंडिक्स सी,
अपेंडिक्स 6 अपेंडिक्स
डिस्कवरी एंड
फॉर्म नंबर
इंस्पेक्शन।
4 देखिए, फॉर्म नंबर 4 ऑर्डर फॉर एफिडेविट एज टू डॉक्यूमेंट, ऑर्डर 11 रूल 12, ये आपको कोर्ट में डालना पड़ेगा at the time of the evidence. This is before the examination chief is filed under section 137 and under order 18 rule 4. So यहाँ पे upon hearing the order so and so within so and so format, see यहाँ पे order 11 rule 13 check करो आप, form number 5 check करो आप, affidavit has to document. I, the above name defendant number CD, make oath as follows. Number 1, I have in my possession or power the document relating to the matter in question in this suit set forth in the first and second part of the first schedule. So these are the maybe admitted documents, not admitted document. These documents are forming part of your in the plain order 7 rule 14. 1 minute, I'll just give me one phone. I'm sorry, there's some important for that. Yeah, I'll just close this lecture. Yeah. So, ये affidavit is filed at the time when the issues are framed by the court. Court gives a direction. Parties are required to, both the parties, plaintiff and defendant, are required to file. So, column number 1 के documents, paragraph number 1 के the documents are falling within the ambit of your order 7 rule 14 CPC. Order 7 rule 11 खोल लीजिए आप, order 7 rule 14. Yeah, protection of document on which the plaintiff sues and relies, मिल गया आपको? All these documents will be forming part of an application under order 11 rule 13, that is in appendix C in form number 5. Okay, ये document आएंगे plaintiff के, और defendant के हो तो order 8 rule 1A खोलिए आप, order 8 rule 1A. ऑर्डर 8 रूल 1A के अंदर रिटन स्टेटमेंट देखिए आप, ड्यूटी ऑफ द डिफेंडेंट टू प्रोड्यूस डॉक्यूमेंट्स अपॉन विच रिलीफ इज क्लेम रिलाइड अपॉन. Okay, this document. Now, item number 2, I object to produce the documents set forth in the second part first schedule. Now, what documents you are objecting? Number 1, you have the document of the plaintiff or the defendant in your, you are a plaintiff. Now, open order 7, order 7 rule 14 में surplus 2 खोल दीजिए. Order 7 rule 14 में why you are objecting I will tell you. Surplus 4 पढ़िए. Order 7 rule 14. Nothing in this rule shall apply to a document produced for the cross examination of the defendant's witness. वो plaintiff की जगह और typographically wrong है जमाने से, defendant witnesses or hand over to witness merely to refresh memory. So this document you are objecting to produce, you need not disclose. Number 1, documents are privileged communication. Open करे, section 122 खोले यहाँ पे of the Evidence Act. 122 खोल लीजिए. Communication during marriage. If their husband and wife के दरमियान letters हैं, communication है, those you may take up the plea. I will not disclose them. 123 के अंदर, if the defendant is the state government, plaintiff is the state government, central government, they will take up the plea that these are the documents of unpublished official record of the government and we refuse to produce the same. These are privileged documents. Every government plaintiff and defendant, when you ask for this document, they normally take up this plea, but the Supreme Court has clarified in Raj Narayan versus Indira Gandhi's case and also earlier 1962 ka judgment, in what cases privilege can be taken, what cannot be taken. I will discuss with you when I am dealing with it. The third objection, official communication, and 125, 126 is important, professional communication between the client and the advocate. So these are the communication. Whatever the plaintiff and defendant will say that whatever communication, whatever instruction given by me to my advocate, these are privileged communication, which I will not disclose it at this stage. समझे ना आप? Now come back. Now come back to again affidavit. Third item आइए. Item number 3. That is a affidavit as a document in appendix C. 3. I have had but now in my possession or power of the document relating to the matters in question in the suit forth in the second schedule. So you are required to admit and say whether you have the documents or not. For example, and I told you, primary evidence की document under 62 आपके पास नहीं है, तो you must mention वो document मेरे पास नहीं है. I am giving notice to the other side. Now paragraph number 5 से clear होगा. Para 5 check करो. According to the best of my knowledge, information and belief, I have not now and never had in my possession custody or power, or in possession custody power of my pleader or agent, or in possession custody power of any other person on my behalf, on account, books of account, vouchers, receipt, letters, memorandum, papers, writing, copy of the extract from such document or any other document, whatever relating to the matter in question in this suit or any of them, or wherein any entry has been made relating to relative to such matters or any of them other than except the documents set forth in it. So मेरे पास कब्जे में यही documents हैं. Mean the documents which are referred to by you under order 7 rule 14 CPC, and in case of defendant order the provisions of order 8 rule 1A, and documents which are mentioned under the provisions of order 11 rule 13 CPC. So reasons, because why? Because our trial is supposed to be Anglo-Saxon trial. Every person is required to disclose, cannot take the other side by surprise. You have a right to formulate your defense knowing the document. Yeah, before the examination evidence starts, this disclosure must be given. In case he is not giving, please make an application as a plaintiff or defendant counsel. You resort to the provisions of Order 11, Rule 14. Order 11 का देख लीजिए. Order 11, Rule 14 क्या कहता है? Inspection मांगिए आप. Order 11, Rule 14, 15. Rule 15, inspection of document referred to in the pleadings or affidavit. So it is not only the documents in the plain and written statement. अगर affidavit में at the time of the interlocutory injunction, appointment of a receiver, appointment of a commissioner, कोई documents किसी party ने refer किया गया है, you have a right to ask for inspection. Order 11, Rule 15. अगर वो inspection नहीं गया था, you can compel the other side to give the documents in the court of law. Non-compliance करने से discovery का, the gentleman will not be permitted to use the document in evidence. See, along with this document, you have a right to ask for interrogatories in the trial which can be used. Interrogatory means सवाल जवाब. This सवाल जवाब. Please note that suppose the defendant may be in a foreign country, वो बोले plea बोलेगा. At the time of the filing of the suit, writ of summons were not served upon me. I was in Australia. I was in USA. I was prosecuting studies. I was out of India by reason of exigency employment. So you frame your interrogatories. I hereby, with the leave of the court may produce करें आप interrogatories, ask you the following interrogatories. In which year did you leave for Australia, America, London? Which month? Please give the details. Where are you prosecuting your studies, in which college? Give me the details of your passport. Give me the details of your departure, your visa, and the duration of your stay. ये सब interrogatories are in the form of nature. See, Order 11, Rule 10 कहता है, in any suit, the plaintiff or defendant, by the leave of the court, may deliver interrogatories in writing for examination of the opposite parties or any of more of the parties. Such interrogatories, when delivered, have a note of foot thereof, stating which of such interrogatories each of them required, provided no party shall deliver more than one set provided. So your interrogatories will become part of your evidence, which you are also required to mention in your appendix C. अभी फॉर्म नंबर 5 के अंदर I also the plaintiff has tendered interrogatories which were not satisfactorily answered by the defendant. ये टेंडर करने के बाद आपको इंट्रोगेटरीज के लिए एक स्पेशल एफिडेविट होता है इसके अंदर, दैट इज आंसर टू इंट्रोगेटरीज. दी सीधा अपेंडिक्स सी के अंदर फॉर्म नंबर 3 है, ऑर्डर 11 रूल 9. द आंसर ऑफ द अबव नेम डिलीवरी इज इन फॉर्म नंबर 1. ये सब रिक्वायरमेंट कीजिए. प्लीज नोट दैट ये फॉर्म नंबर सी के अंदर आइटम नंबर 1, आइटम नंबर 2, आइटम नंबर 3, आइटम नंबर 4, 5, order of protection number 6, notice of protection order 6, 17. So these are the parties of this document. Take inspection before the court of law and produce it, and the court will consider the legality, propriety, correctness, whether as regard the admissibility, admit करना है नहीं करना है. Now उसके लिए 2 relevant section which I am pointing out, both
Excuse
under
me,
the,
sir.
हाँ जी,
Sir, just a reminder, it's 6:40. We will have to wrap up our lecture now.
640.
Yes, sir.
Yes, 645 को खत्म करता हूँ. 645 को another 5 minute दे दो.
Sure, sir. Sure, sir.
5 minute में ले ले, खत्म कर देंगे बाद में. Yeah, because it's a very relevant topic I'm discussing with you. Yeah, section पे आ जाइए, relevant section 136 पे आ जाइए. See, the court of law, when you tender the document, the honorable court the trial court, which is a trial court which is seized of the matter. If it's a civil court, the court of district court, the high court deciding original matters, the civil judge senior division, junior division, or in the criminal court, court of session, civil, or a magistrate's court. Now 135, 136 is a relevant section. See that here. When either party proposing to give evidence of any fact, the court may ask for a party proposing to give evidence in what manner the alleged fact, if proved, would be relevant. And the judge shall admit the evidence if he think fit, the fact, if he prove, would be relevant or not otherwise. If the fact proposed to be proved is one of which evidence is admissible only upon proof of some other fact, then the last mentioned fact must be proved before evidence is given, unless the party undertakes to give proof of that fact and the court satisfied without such undertaking. Then illustration बाद में पढ़ूंगा आपको मैं, ये आई थिंक नेक्स्ट लेक्चर में कैरी फॉरवर्ड करता हूँ. ये सेक्शन 136 देख लीजिए आप. और सीपीसी के अंदर the relevant section is order 13. Order 13 देख लीजिए आप, then I will discuss with you. Order 13 of the Code of Civil Procedure is to be taken into consideration. Order 13, Rule 1, Rule 2, Rule 3. ये पढ़ के आइए next time. And CRPC के अंदर, those who are doing criminal trials in the matter, please note that what you are required to understand in this matter is section 270, ले रहा हूं मैं, 200 या chapter 23 खोल लीजिए आप evidence में. Section 273, evidence to be taken in the accused trial. Yeah. Then हम document के बारे में बात करें. Record in which evidence may be complied with, interpreted record of the High Court, attendance of the commission to be taken, return of the commission, adjournment, execution, disposing, identification of the witness. Then I'm giving you the relevant section, affidavit in proof of the conduct of public servant. Section 295 will come to when it is a public servant, and then evidence of formal character. इसके बारे में affidavit, the parties have a right to ask for interrogatories. एक special section है अंदर CRPC में, मैं आपको दे दूंगा उसके अंदर. So mind it, you read the provisions of a CRPC for recording evidence, chapter 23 पढ़ के आइए आप. I will discuss it with chapter 23 in the CRPC. Of course, it is easier because last time we had read it, and I will tell you what is the how this evidence before the criminal court, a magistrate or a session judge will record it, and under the provisions of Code of Civil Procedure, Order 13, Rule 1, 2, 3, and Order 18 CPC. Order 18 CPC, पढ़ के आइए, read with section 135 and 136 of the Evidence Act. I will wrap it up here with this. Then I will discuss the further scope of जो section 66 में Evidence Act के अंदर you gave a notice to the other side to produce the original document. अगर वो नहीं produce करेगा, तो the copy which is in your possession is exhibited and admitted in the evidence, and how the court accepts it, I will carry forward on the next lecture. In case I am available on Friday, I don't mind taking one lecture Friday. Please, Kumar, check up with me. Friday के अंदर we can take one lecture. I don't mind. Okay?
Sure, sir. Sure, sir.
Friday. So anybody has any question for today's lecture, please ask me. Briefly, 2-3 minutes are available for lecture. I can request our Raghav, I told him I will take the lecture from 7:15, no problem. Raghav is always very accommodative and very indulgent. So anybody has any question, I can give you another 5 minutes for question answer. Hopefully you are understanding the Evidence Act, isn't it?
Yes, sir. Yes, sir.
समझ में आ रहा है, because since you are at CPC, CRPC or Evidence Act will easy become, I will wade you through the various provisions of the 3 Act, दोनों साथ में रखिए, और Registration Act भी साथ में रखिए, वो भी easy रहेगा. Anybody has any question, please?
Sir, can you explain the bailiff and bailiff report? I got confused with it in the
bailiff का report क्या,
initiation of the
order
lecture.
5. See, plaint file होने के बाद, plaint is filed under the provisions of Order 7. read with section 26 of the Code of Civil Procedure, along with the affidavit. प्लेंट होने के बाद ऑफिस विल रिमूव ऑब्जेक्शन में निकालेंगे आप, सूट नंबर मिलेगा आपको एडमिट होने के बाद, कोर्ट एग्जामिन एग्जामिन। फिर उसके बाद अनलाइक द क्रिमिनल केस, a plaintiff is required to serve the copy of the writ of summons along with the copy of the plaint. वो provision है order 5 of the Code of Procedure, order 5 and section 27 of the CPC. Order 5 तो पढ़े ना आपने? Order 5,
yes sir.
Order 5 भी पढ़े,
Yes,
section 27 भी आप ध्यान दे देना. Section 27 deals with the service part. If I'm not mistaken, check करो. Summons to defendant, section 27. Summons upon the defendant residing out 28. 27, 28, 29, 30, 30, 31 तक वो पढ़ लीजिए. तो a summon, writ of summons and a copy of the plaint, the bailiff is an officer of the court. Sheriff of Bombay, Bombay में है. Other bailiff is an officer who takes the copy of the summons and the copy of the plaint or any court process serving upon the other side. So bailiff is a petty officer of the court. He is a serving officer. क्या? वो report बनाएगा. हाँ, वो report बनाएगा. I had gone along with the plaintiff or his representative to the defendant residence at so and so place, at flat number so and so, for serving the writ of summons. I found defendant or his wife, I gave a copy, or I did not find anybody, premises was locked, he will report. I reached there at 10 o'clock in the morning at so and so, on Monday, on so and so. Timing लिखना पड़ेगा उसको. Before sunset and after sunset, क्या ना? Sunrise and sunset, वो rules हैं manual के rule. So I made inquiries from the neighbor as regard the whereabouts of the defendant. So he was not available. So minimum 3 attempts are required to be made personally as per the bailiff, as per the High Court के civil manual check करो आप. Civil manual check करें और criminal manual for criminal writ petition, criminal cases के लिए criminal manual. उसके अंदर लिखा गया writ of summons किस तरह सर्व करते हैं. Writ of summons in the CRPC section 60 onwards. In the CPC,
Sir, in CRPC, police will be serving the summons on behalf of court, right?
Or the court may direct anybody, any other person, because investigation can be done by police officer, even some private person. Magistrate can direct anybody. There is no bar. It can even normally a police constable is the bailiff in criminal cases. Section 60 is the relevant section in the CRPC. All of you knowing that the summons are served 61 onward. Sections, that is chapter number 6 check करो. Section 61 से लेकर 69 तक process summons है और warrant comes into play from 70 onwards. 70 से लेके 81. अगर दोनों को obey नहीं करेंगे तो proclamation of attachment लगेगा. Section 82 से लेकर 86 लेकर. A very beautiful drafted scheme both in CPC and CRPC. So a bailiff is a petty officer who serve the writ of summons. समझ में आ गया अभी?
Yes sir, yes sir. Thank you so much sir.
और कुछ पूछना है किसी को?
No sir, thank you sir.
Are we going properly? Slowly जा रहे हैं, fast जा रहे हैं, बराबर जा रहे हैं?
जरा मुझे आइडिया दीजिए. I think someone else said should, because I think I'm very much comfortable with this speed, sir.
Okay. Anybody says that here I am required to go further slow or fast, please do feel at liberty to do so, and we'll adjust accordingly. Okay. अभी I am prepared to take one lecture on Friday subject to your availability. बताइए मेरे को. Otherwise we are meeting Monday and Wednesday same time 5:30, 5:15, 5:30 भी लेंगे. Okay. Chalo, good night.
Sure, sir.
All of you then. All of you, good night.
Good night, sir. Thank you, sir. Bye, sir.
Good night.